Mr.
Lady Lords,
Jones.
good morning.
I'm sorry to keep you waiting.
Not at all. It's asserted that the employment judge came off the rails more or less immediately in the first judgment. We say he does not, but in order to demonstrate that, I'd like to spend a few minutes just painting the picture of what the rails actually are. So I'm afraid this first section of what I'm going to say to you is likely to come across as insultingly basic, but I think it's important that we all understand what we have agreed about what the nature of the law is on this particular point. So we all agree that the ultimate question under section 65(6) is whether the work which is done by the claimants is equal to that of the work being done by their comparators. We all agree that that's reached, as the section further explains, by a sort of legislative alchemical process in which work is transformed first into demands, and demands are then accorded a value, and then the two values are compared one against the other. We're also all agreed that the Act does not, either at section 65 or elsewhere, give you any specific additional guidance as to what work means. Lest I cause panic, let me say straight away that we say now what we've said throughout, which is that in defining what work is, you are looking for the work that the claimants and comparators actually do. So that, we say, is the correct test, and I'll come in a moment to the authorities, albeit I hope with the right touch, but we're not seeking to resolve from that position, and we don't think that the tribunal did either, for reasons that I'm about to make clear, I hope.
And the Act is structured in such a way that you are looking at individual A and B and not looking at generic jobs, and everybody agrees that.
We agree that. So it's pretty clear that you need a claimant and you need a comparator.
Yeah, but they're not notional. What would a notional Tesco customer assistant in an express store do? It is, what does this particular person do?
So and that's the point which, of course, the Lord Justice Underhill touched on in Preston Michel in footnote. What I take from that footnote, because the footnote is very clear that there's no intention to suggest that the ordinary practice of identifying a particular claimant as a particular comparator is wrong or should anyway be abandoned, is that for some jobs, either claimants or comparators or both may be in a sense fungible in that what they do is so similar that it doesn't really matter which one you choose, unless, as I outlined yesterday, you then pursue the process to such a level of granularity that you're able to eke out some particular atypical feature of the job.
The super Wayne.
Super Wayne, and we will come back to Super Wayne because it's one of the examples given yesterday about where it said the tribunal went wrong. But you'll notice that I placed an emphasis on the work that they actually do. And the reason why I do that is because I say in approaching an otherwise undefined statutory term, you should of course give it its ordinary meaning, its normal meaning, its meaning in ordinary usage. One way of looking at how people generally understand work is that the job is classically a work-wage bargain. So what the employee does is the work, and what the employer provides is pay in return for the work. So the work is what the employer is buying. It's the consideration which is provided for the pay. And that, I think, is a helpful touchstone in an equal pay case because we're talking about what people should be paid, what they should receive in return for their work. But the reason why I emphasise this is I think that the question, what is work, undoubtedly a question of fact, is really two questions of fact. It's a compound question. So the first question is, to look at it in purely observational terms, is what are they actually doing at work? So you first look at what the claimant actually does in the sense of the activities that they're engaged in, the tasks they are completing, and you do that too for the comparators. But there is a discrete question, which is what they are doing actually work? And this is a distinction which Tesco accepts. So let me make that plain to you. I can invite you to look at their skeleton arms.
Sorry, because this is obviously important, but even before you show us whether Tesco accepted, I haven't quite understood in what sense what someone does is work. Is this the loafing point that we got out of Beale?
It's the loafing plus, so I'm going to say. So loafing is a very good example, but that's an example of the central principle that an employee cannot redefine their work by simply doing something which they're not entitled to do. They've been told not to do, for instance, by doing nothing, which is the loafing example. And we'll come, I hope, to some particular examples of arguments that were put in relation to claimants, where it was said, well, you may be doing this, but if you're doing this, we didn't know you were doing it, we don't want you to do it, it's not part of your work, and we're not paying you to do it.
And this is the point the employment judge made about an unauthorised way of working.
Exactly.
Okay.
So when one looks at paragraph 3.5...
Sorry, yes, you're now doing what I was stopped you from doing, going to Tesco.
Yes.
Yeah, okay, fine.
So it's Tesco's skeleton argument, paragraph 3.5. They say in the first line, Tesco accepts that not everything that a job holder does in the workplace is necessarily work. And for that principle, they rely, as they should, and as indeed as we have, on the judgment of Mr. Justice Lavender in Beale and Avery House. So we agreed.
Yes, I understand entirely that if you're just loafing around, if you're not doing anything,
Yes.
then you can't say I'm working. But it is not so obvious to me that if you do what you are asked to do, but you do it in an unauthorised way. Suppose, for example, you're stacking a cage, assembling a cage,
Yes.
and you're told very clearly you have to assemble it this way.
Yes.
And we've got lots of photographs showing you how to do it and how not to do it. If you stack it the wrong way, that's an unauthorised way of doing your job, but you're still doing your job. That's still work, is it not, even though it's unauthorised?
Well, I'm going to draw a distinction, if I may, because it's going to be important. There are different categories of case. So there are categories of case where you're simply doing something you're not supposed to be doing at all.
Yes, you're not meant to spend your time answering private emails while you're at work. Fine, I
Yes,
understand.
to give
That's
you
not work.
That's not work. But to give you a more specific example, we'll come to an example involving Mrs. Cannon in a moment. But when we were dealing with Siobhan Williams, who was a customer assistant in an express store, one of the things she said she did was carry bags to the cars of customers. So what was put to her in cross-examination is, you're not supposed to be doing that. It might feel like work, so there you are in your uniform. These are customers, you're a customer service agent.
I thought the traditional definition of work was moving objects at or near ground level, which is exactly what you're doing.
Shifting atoms, yeah.
Yes.
Yeah, but their position was, if you're doing that, you're not supposed to be doing that. We didn't know about it. So this is the point, really, that Mr. Justice Lavender really fixes on. He says, there are circumstances in which you may just be allocated a task. There are circumstances in which you may be allocated a task and told how to do it, specifically. And if you are performing the task and you're doing it how you've been told how to do it, there's no doubt at all that that is work. So then he says, well, look, there's another category of cases, which is where you're performing the task, but you're doing it in a way which you haven't been asked to do it. But it's simply a way of performing the task. So you haven't had a stipulation that you should do it in a particular way. He says, well, that must be work too. If your employer is not saying you must do it this way, providing what you do is a sensible and ordinary way of carrying out the task, then fine. We would say, by way of footnote, and taking a hypothetical example against myself, if what you do is you adopt an entirely and obviously ludicrous way of doing it, something which massively multiplies the effort when there's a very straightforward way of doing it, must ultimately be open, we say to the tribunal, to say, well, what you're doing is running up your points, to use Mr. Reed's term, and you're running up the value by doing the job in a way which you must have understood that the employer did not want you to do. So you can't increase your own pay, effectively, by going about things.
Carrying bags to the car, in a sense, might be quite a good example. I don't know what the rest of her duties were, but suppose the rest of her duties didn't involve any moving of stuff. It was entirely answering customer inquiries, saying that the yogurt's in that aisle, and so forth. So there's no physical, and no lifting and carrying, which is one of the things that goes into you get points for.
Yes.
And she says, well, at least once an hour, I carry some heavy bags out to the car park. I'm sorry, if I'm just spelling out unnecessarily obviously. And she gets 5 points of physical effort.
Exactly right.
Yeah.
So it's, I mean, I continue down this path. So there are circumstances in which you just do something which is an obvious way of doing it. It may be that you do something in a way which is flatly contrary to the way you've been told to do it. So on the face of it, the initial response might be, well, this doesn't look like work. What in fact happens is your manager observes you doing it that way and is perfectly happy that you should do it that way. So this is what Mr. Justice Lavender described as condoning a way of doing the work. In between the two, you might be encouraged to do it in a particular way. So you might be told how to do it, you might be encouraged how to do it in a particular way, you might find your own way of doing it, and that might be condoned. And that's the essence of how the Super Wayne example is approached on behalf of Tesco. They say, well, what he's doing has got nothing to do with the way in which we train people, but he does it his own sweet way, and we have condoned that as a way of doing it, and therefore it's work, and it's work which imposes different demands on him, requires different skills to how other assemblers work. But at each stage so far, what you have, I don't want to overstate the point, is a kind of explicit or implicit employer's consent. So you're either doing what the employer specifically wants you to do explicitly, or you're doing it in a way that no reasonable employer can really object to and doesn't object to, or you're doing it in a way which the employer might have objected to, but they've seen you do it, they're aware of it, and they're not preventing you from doing it. The boundary for Mr. Justice Lavender is not simply when you do nothing, the sort of what we've described as the loafing limit alone. But if you do something, if you take on a task or you perform a task in a particular way, which is, for instance, unapproved in the sense, in fact, even potentially stronger, it may be contrary to how you've been told to do it. The employer doesn't know you're doing it in that way, and you don't have either an explicit or implicit condoning by the employer. Well, in those circumstances, that seems to us to be beyond the boundary of the work that you can rely on to generate you points. Now, the Lord Nugee asked me a difficult point, which is there's a completely different way of approaching all this. And it was a way which was, we dealt with in Beale too, we argued in Beale, which is to say, well, never mind what the employer is asking you to do, what the requirements are. When someone, for instance, moves bags to the car, that's work, isn't it? Because they're at work and you're helping a customer. So if you stood back and said, is that work? That would be one way of thinking about it. Certainly not leisure. So in effect, by process of elimination, you say, this is not them doing nothing. It's not them taking time off. They're not on a break.
They're not doing it for their own purpose. They're not doing personal stuff while at work. They're doing stuff that's in the context of their job.
So that, I think, is an alternative, as it were, kind of broader approach to a definition of work. But it's not, I think, where Justice Lavender ends up. Yeah. And it's not where we've agreed, in effect, the appropriate course is. So certainly, witnesses on both sides were cross-examined on the basis that if they were doing X, then X was something they were not supposed to be doing at all. And without wanting to sort of spoil the surprise, in relation to Wayne Jones, for instance, the suggestion that he was putting things in different cages because it was more efficient. He wasn't putting the particular product in the particular cage that the voice on his arm was telling him to put it in. Well, if you put things in the wrong cages, you were supposed to scan them as they went in and scan the cage. It produced an error. And if you had too many errors, you were disciplined for it. So what is now being described as the thing that he did, which was his special way, was something for which not only were other people disciplined, but he was disciplined for it. So that, when one gets into the granularity of the fact of it, that's where one ends up. One's looking at asking oneself, not just is this a thing that someone does, and is it not done for their benefit, their own benefit? But is it something which is work in the sense that the employer has asked for it, encouraged it, condoned it, seen it and allowed it without challenge, however quite one wants to put it? Do you have an implicit or explicit consent from the employer to be doing this in this way? And the reason why in this way matters is, of course, that generates points. So how you set about doing, it's not just the task you do, but how you set about doing the task generates demands, generates points, generates potentially income.
Yes, it's another big picture point. The point you're making, or the whole debate we're having, is actually we're neutral as between claimants and respondents. You could get a case where it very much benefits a claimant because they have been doing much more than they were asked to and been getting points. You could get a case where it benefits respondents because the comparator is someone who is doing more than they were required to do. Obvious point, I'm just sort of fitting it back. There's nothing really tactical about this. In a particular case, it may be a claimant's point, in another case, it might be a respondent's point, or both may be taking it in respect of different people.
That's right. So to give another example that I don't think came up in this case, but I've certainly seen in other cases, you may have someone who's effectively the son of a shop floor elder. So they've been there longer than their colleagues. And they effectively appoint themselves supervisor. So they don't have a supervisory role, but what they do is wander around telling other people that they're not doing things right and saying, well, I wouldn't stack it that way. This is how you should stack it. It must be open to an employer to take a point against claimants to say, well, in an equal value exercise where you suddenly say supervisors are paid at a higher rate, I am supervising, I am not paid at that rate, they must be able to say, well, we didn't appoint you as a supervisor. Maybe that you've taken it upon yourself to do that, but we didn't know you'd taken it upon yourself to do that. And if we had, we just made it clear to you, you're not supposed to be doing that.
Well, it's not even, although it's quite subtle, it's not even, you mustn't do this, you're not supposed to be doing this, but you don't have to do this, and we're not asking you to do this.
And we're not paying you for it.
And we're not paying you for it.
Yes.
And if you go on doing it, it's because you like it and the others, but now you could get some very subtle arguments because if he really is helping people out, the employer might be said to be condoning. But in a pure case, unauthorised isn't quite the wrong word. It's more, it's a concept of a volunteer, really.
Yes. So I think what is unhelpful in the way in which it's been approached in the language of the tribunal is that although the tribunal does cite Beale and says these are very useful passages, and we think does its very best to follow Beale, it uses the language of requirement, which is the strongest possible version of the situation that I've just described, where you have an explicit requirement that you should or should not do something. And when it describes its aversion, the tribunal's aversion to the notion that you just look at what people do, it's not, we think, rejecting the test, that you look at the work that people actually do. What it's doing is rejecting the notion that you just simply look at the activity which is being carried out. The difference between how we put it and the tribunal's perspective is, and we'll come to the judgment in a moment and I'll show you, they have a long passage in which they ask how did we go wrong and how they think we went wrong, by focusing unduly on oral evidence and neglecting this point that there is, however one wants to put it, a loafing limit, or that there's some requirement in deciding whether or not something is work for explicit or implicit employer approval or consent. So that's what, when you look at the passages that you were shown by Mr. Reed during the course of his submissions, that's really what they're saying. And it's not just me who reads it that way, as you'll see when we come to it. That's also how Mrs. Justice Stacey reads it. She says, when they're making these points, when the tribunal is making these points, what they're actually focused on is what I would call the work boundary, the work definitional boundary. So just to retrace my steps a little, it's a compound question, it's a two-element question. What are they actually doing when you watch them? And is what they are actually doing something which counts as work in the sense that it has this overall employer blessing, as it were.
And just going back to the point you made before that, almost, is this what they're being paid to do?
Yes, it's another formulation. Is this what the employer is paying them to do?
In other words, when you ask the statutory question, is A's work of equal value to B's work? It's not, does A do things which are as difficult as what B does, but is what A is being paid to do and does of equal value to what B is being paid to do and does?
Exactly. So, and my Lord Justice Underhill was right. The qualifications at both ends of the test, so that you make sure it's
Yes, no, that I understand.
Yeah.
I still have, I understand it all in theory. Can I go back to my practical example of someone who stacks a cage but doesn't do it very well and does it contrary to what the manual says? You should stack it so that everything is horizontal, and you can see photographs of cages where things are stacked, shoved in diagonally, and that may lead to cream cakes being crushed and having to be thrown away and so on. I understand all that, but the person who's stacking the cage badly is still stacking the cage. That's still what they're paid to do.
He is, but he or she doesn't get more points for stacking it badly, if you see what I mean. So
No, but they don't get no
point.
You don't say when they're stacking the cage badly they're not working.
We don't say that.
You don't say that.
No.
So it's not a simple way of saying it's an unauthorised way of doing your job doesn't count, because that is an unauthorised way of doing your job in a way. So it's a bit more subtle than just saying, are you doing it in a way that the employer has
It is
authorised?
The tribunal actually picks up on the subtlety. So as we all see, they say when they're making the point that you can't essentially redefine your job by either not doing parts of it, or they say you're doing it badly. So
That's ambiguous, isn't it? Doing it badly. If they are actually saying simply you've stacked the cage badly, you haven't paid careful attention, and it's all lopsided, you're not saying, and you say they're not saying, that you don't get paid for that. You don't. That doesn't go into your cage stacking doesn't count as part of what you do.
Yes. So
the question of unauthorised, if that's the right word, or volunteer, captures it, is more relevant to actual things that you do that you're not asked to do.
yes. So there is some subtlety to it. It can cover method. So let me address the point head on. I think we're agreed that how well you do the job or how badly you do the job is not a matter for valuation. So Brunhofer is a case specifically where the Court of Justice asks itself, if you are better at the job, should you be entitled to more pay? You know, is personal, individual performance a difference? And my recollection, we can go to it in a moment if you wish, is that they say, well, that may justify a difference in due course, but it doesn't necessarily affect the question of whether you're doing a different job, although it could. So you might have an additional skill. So in the Vienna doctors case, for instance, the fact that some were doctors, some were psychotherapists, they were on the face of it doing identical work, but what was said is you have skills as doctors which allow you to do more work in a field of psychotherapy.
Yeah, but that was to do with some sort of objective characteristic training, which even though day to day it might not make much difference, is something that employers we know pay more for, and it's really pay more for.
Yeah. So to move on from that essential premise that how well or badly you do the job, save in exceptional circumstances, shouldn't affect the valuation. And to take a ludicrous example, you might have three assemblers, one of whom just assembles straightforwardly in accordance with the guidance and produces well-formed cages. Then you have someone who's sort of slovenly and throws the pallets into the cage, damages product. We accept they're doing the same job. The value is the same. But you might have someone whose approach is to grab the pallet, climb to the roof, swing across from one part of the roof to the other, take careful aim and then drop it into the pallet. And he says, well, look, my physical effort is 100 times greater than these other people. the employer must be entitled to say in those circumstances, but what on earth are you doing that for? You're not supposed to be doing that. So that's the difference, I think. I may not have identified it quite as precisely as you might have hoped I was going to.
No, but making the point you're making does bring into the equation in a subtle way, and which doesn't undermine the basic principle, is a one-on-one comparison, but it does bring in elements of what is the generic job.
Yes. Which, sorry, but just absolutely the point. So that if I communicate nothing else, that's the point. So when we come to the question, did the tribunal approach this on the basis of generic jobs? I'm going to say they don't. But what they're entitled to do is to look at generically what the job is as a tool to get them to the finding they actually need to make, which is whether or not the claimant or the comparator, what work they are actually doing. And again, I stress work to bring in the kind of extended deal understanding.
And another point which emerges from your example is the value. It's not the value to the employer, because having a perfect employee is more valuable than having a slovenly employee.
Yeah.
But the value is the demands on the employee, which should be the same.
Yeah, so that's when I described it as an alchemical process earlier. That's the oddity of value. Value in the Act is simply a measure of the demand that it places on you. So you could rationally, outside the context of equal pay, say the demands aren't necessarily an indication of value. So that if I work in a mine, the physical demands are incredibly demanding. If I instead stand up in Court of Appeal and make points on behalf of clients, arguably less demanding. But
physically less
get paid more than the miner is going to be paid. So the particular kinds of work, particular kinds of demands might have less value to an employer overall in the very broad sense, but that's not what the Act is interested in. The Act is interested in asking how demanding is this role, and when we add up those demands, we get to a value. So it's an equation first of work with demand, and then with demands to value, but I think in quite a narrow sense. You don't ask the employer how much they value it. You look at the job and work out what the demands are in total.
Which produces an oddity, because employers presumably pay people what they think they're getting, what they think they're worth. They pay people who are more valuable more money.
Well, it doesn't. Of course, in absolute theory, that's right. A good employee is worth more and will be, in principle, paid more. But in all jobs, probably, or most jobs, but certainly in these jobs, you don't have individualized job pay setting.
Yes.
It is in the interests of employers to average out, and you will always get people who, in one sense, are underpaid because they're brilliant at their job, but they're brilliant at a job of which the actual demands are X, even though they are performing, make it work, super X.
Yeah.
And sometimes you can get round that, if it matters enough, this you get out of Brunhofer, I think, by having separate merit awards or bonuses, as long as they're objectively measurable and so forth, for better performance. And those are different from what you're looking at from the point for the equal pay exercise.
Indeed. So the reason why we say, I made the point I did earlier about the quality of the performance, is generally speaking, in approaching these matters, what your work is and how well you do it are seen as two separate concepts. And very often, as they are in this case, at least at certain warehouses or distribution centres, remunerated discreetly, so that if you are ahead of your target, you may receive a bonus for being ahead of the work rate that you have been set. So we're really only concerned with the first point, which is what are the duties and how do you draw the boundary? So in other words, if you still have 3.5 open in front of you, this is a point I'm going to have to come back to very shortly and develop a little further, after I finish with the basics, as it were, that you will see at 3.5 of the Tesco skeleton, I've taken you as far as the end of the quote, I think, from Mr. Justice Lavender. They then go on to say the activity in question must be capable of being considered work. But then they say, however, the boundaries of that concept are not defined by the requirements of the employer, whether in principle or in justice. Now, we think that's not only wrong, for reasons I hope I've taken at least some steps towards demonstrating so far this morning, but it's not what we agreed the law was. And I'll come to that, as I say, shortly, because it's not what Mr. Justice Lavender says in Deal. So we should, I just would like you to note, if I can prevail on you, that although Mr. Reed says this is all an entirely agreed position on the law, it looks like it may not be entirely agreed in that respect, how you define the boundary of what work is, and whether you're entitled to look at responsibility and requirements. Not responsibility, requirements, and looking at it. So
just to be, one way of putting this is, you say the agreement was basically to follow Beale. I mean, we're not bound by Beale, but you say it's right. But anyway, you say Beale was the touchstone that everyone agreed to follow, and you can't, too late now to say, to try and change it.
Well, to put it a bit more precisely, although we were given credit below by Mrs. Justice Stacey for how we put together our summary of the law, it's really just quotations from Beale with footnotes pointing at the relevant passages, along with some references to Chills and Coombs. So we certainly used it as our model, and when we made our submissions, both in opening and in closing, that's the approach that we took. You'll be aware, just dealing very shortly, and I apologise a little vaguely with the chronology, when we sent in the joint note, the Tesco's position at that point was that they weren't prepared to say whether they agreed it or not.
Yeah.
So it wasn't a question of whether they did or didn't, they just wouldn't say whether they agreed it or not. No doubt with one eye on the fact that they had an appeal live in the AT by that point. They knew more was coming from the tribunal. But by the time we reached the EAT, their position was that they did accept that it accurately stated the position.
When you say reach the EAT, you reached the EAT twice. Was this
more than twice? But when we reached the EAT to deal with this question,
This was in front of Stacey rather than in front of
Taylor.
Yes.
And my recollection is that an earlier hearing, I can't now remember the specific context because there's been so many. Mr. Epstein also, who was Mr. Reed's predecessor, accepted that the note was correct, subject, I think, to one word which he thought had been rather infelicitously drafted. But their position now is that they stand on all fours with what we drafted. So I want to move, if I may, to the next point, which is this. If you've got these two questions of fact to determine what they actually do in terms of activity day to day, is it work? How should a tribunal approach that question? Again, the obvious propositions say they have to take into account all of the relevant evidence and weigh the evidence and reach a decision. So what evidence is going to be available? Well, in this case, as in almost all cases, there were two sorts of evidence available. The first was documentary evidence. And what Mr. Justice Lavender has to say about documents such as, quotes, contracts, job descriptions and work manuals is that they're relevant but not necessarily determinative. And you may recall, but if you don't recall, we will come to it, the tribunal says, aha, well, if it's not necessarily determinative, that means that it may in certain circumstances be determinative, even if it is not always not necessarily determinative. Why, as a matter of general principle, might it not be? And the answer is because the document that you're relying upon may now not accurately reflect the work that is being done on a day-to-day basis.
So, are you really saying, while not endorsing all the things maybe that the tribunal said, which are rather hyperbolic and unwise, that actually there is, in principle, it's not a bad thing to start with manuals, because that shows you what you're expected to do, and that it shows you what the employer's paying for.
Yes.
And now, of course, they could be obsolete, they could not reflect the reality in various respects, but still, they're not a bad starting point.
Correct. Exactly what we're saying.
Yeah.
In fact, we're going to put it a bit more strongly in a moment, but that is what we say any fact-finding tribunal is entitled to do, which is to say we've got this pool of evidence, our job is to compare it, we've got oral evidence about what people say happened at work on a day-to-day basis, we've got documents which tell us on the face of it what Tesco thought should be happening at work on a day-to-day basis. Our job is to weigh those things together in the balance and reach a conclusion. And you can really start from either end of the process. So we had said in the joint note, the starting point is what people actually do. So our position was start with the oral evidence. And then we tested, and indeed Tesco tested, the witness evidence that was given in the case against the training material. And the tribunal certainly could have done that. So it could have said, here's what everyone said. And there's a dispute between the parties. In just Tesco say Mrs. X did not do job function Y. But when we look at Tesco's own training materials, it says that people in the position of Mrs. X should be doing function Y. So we take all that into account and we have decided that we prefer the evidence which has been given by Mrs. X on this particular point. That is absolutely classically what a fact-finding tribunal should be doing, and also, and equally classically, how they start it, what weight they give to particular evidence, their approach to weighing evidence is a matter for them. So again, I will come to this, but one suspicion is that what happened is that the tribunal retires with all this material, including hundreds of pages of witness statements and weeks of transcripts, trying to find out and determine for themselves what the job is. Although we've referred to training materials, we've referred to a small subset of training materials for particular points. When they look at the training materials, what they find is often in-depth descriptions of what the job is supposed to be. Now, it's possible that that training material is relevant but unreliable because it has drifted, it's out of date, it's drifted away from what actually happens. So they had to take a view as to whether or not this training material was going to be reliable in order to determine how much weight to put on it. But they then make findings of fact, and the lady Justine asked me yesterday, do they make a finding? I promise you I'm coming to that very shortly, where they say, this is a really unusual situation. In effect, this is an employer who has standardised roles, lots of training, regularly updated. This is reliable in a way that we feel entitled effectively to start with it. It also says, sort of metaphorically, angry, shaking a fist at the parties, and you should have started with this. You know, why have you wasted our time with weeks and weeks and weeks of contested oral evidence when here it all is? You should have taken the same approach. We disagree with the tribunal, but we say it's ultimately open to the tribunal to take that approach. So, again, to take a step back, it's an effort, it's an exercise in looking at the evidence. You've got documentary evidence. The documentary evidence may or may not be reliable. So the job that it describes, for instance, may have changed. It may have changed consciously because the employer's asked for a change. It may have changed because the employee has found another way of doing the work and the employer has condoned it. All the ways that we've already discussed. What work is done on a day-to-day basis may drift away from how it's been described in the documents. So Mr. Justice Lander is entirely correct to say, well, these are not necessarily determinative. You cannot, as an employer, just turn up and say, well, look what the contract says, or look what the training material says. We've got to look at what's actually happening. And that's the point, the work actually done, which we think Shields and Coombs and Brunhofer is authority for.
And of course, the reliability will depend very much on the kind of employer it is. I mean, Tesco, it seems, but it doesn't surprise me, huge body, lots of back office stuff, produces lots of manuals, and is very prescriptive. Even so, but you could imagine other employers who produced a training manual 10 years ago and are just not organised enough or motivated enough or have the resources actually to produce every time they have a completely new computer on your arm, they just don't do it, in which case the training manual will be worthless.
Exactly.
And all stages in between. And so Mr. Justice Lavender must be assumed to be bearing in mind that not all employers, well, I forget who the employer was in Beale.
The care home group.
Right.
I mean, Beale was a fascinating case, but it had some. It's one of the first cases I think which has thrown up some of these difficult issues. So one of the issues factually in Beale was whether the comparators who were handymen, because they led prayer for residents in the care homes, that was also part of their work. So what was and was not work was something that came to the fore in a way which it often doesn't in a case like this. But in fact, in this case, as we'll see, sometimes it did. So Shield and Coombs, when they talk about, you look at what the work which is done in practice, that's what we think they have in mind, this kind of compound test. And in terms of one's approach to the evidence, just for your note, I won't take you there unless you want to be taken there, but Lord Justice Orr at 171F says you can't just rely on the documents in their entirety, but equally you can't rely on the witness evidence. It's a question of looking at all the relevant evidence. And I scarcely believe I'm saying that out loud. Of course, you have to look at all of the relevant evidence in a case. In Brunhofer, which the tribunal cites to itself, they're criticised for not looking at paragraph 42 and 49, where the references at 42, for instance, to the work actually performed, but we say, well, that needs to be understood in the way that we've earlier identified. What they're particularly interested in is at paragraph 48, the way the European Court puts it is it's the activities actually entrusted to the employees in question. And that entrusting is a variation, I think, of what we were discussing earlier, which is it's the employer identifying what it's going to pay you for. These are the things we want you to do. So we don't think either Shields or Brunhofer prevent the tribunal from saying we're going to take into account all the relevant evidence, including the training materials, and if we think the training materials better identify what the quotes requirements, as the tribunal would put it, are, we're entitled to do that. So of course that's documentary evidence, witness evidence. Mr. Justice Lavender, again, we say with great wisdom, says, well, that also is not necessarily determinative. And not just because witnesses may come up, may attend in front of the tribunal and quotes over-egg what they did, which was something which came up in the course of this case. But there are all sorts of circumstances in which merely accurately describing what you observe happening on a day-to-day basis might not be the right approach. So, Lord Justice Underhill, you identified one circumstance, I think on day one, which is the Potter situation, where you've got a responsibility which isn't expected to recur regularly. It might not occur at all in the course of the relevant period for assessment. So if your job is pushing the nuclear button in the event of attack by Russia, if it doesn't happen in the 5 years of your period of claim, you don't just say, well, that's not part of your responsibilities, because it's obviously the most important part of your responsibilities. So it's not just mechanically looking at what happens, Potter says. Loafing, as identified in Beale, you can't say, well, in fact, what I do is sit around all day, or to use an example from a case I had fairly early in practice. If you were a night patrol officer for a local authority and you just went to sleep, you couldn't say, well, my job is sleeping.
Well, funnily enough, I was thinking of that. Probably because night watchmen are very important in a different area of law about minimum wage.
Yes, as we were engaged in the Mencap case on that. But so equally, and this is where I think it might be helpful to look at Beale. So Beale, I think, is tab 29, if I remember rightly. And if I can invite you to look at paragraph 32.
Reporting.
No, inconveniently. So I don't know quite who won lobbies to get it reported. But if at the end of the hearing you decide to approve it, that might.
I don't like very long judgments, so maybe it.
So at 32, let me just read it to you. It says, of course, where an employee is contractually required to do something, that requirement does not fall into desuetude or otherwise been varied, then that activity will form part of their work, even if in practice they neglect or refuse to perform it. But most of the issues in the present case concerned activities where the contractual position was not so clear-cut. On the whole, the dispute was not as to what the employee did, but as to whether it formed part of their work. So that's them asking the second question that I've just described in the compound question about the work and activity did. So I will deal with individual issues later. It may be helpful to set out in general terms what seems to me to be the appropriate approach. In general terms, therefore, one, where an employee is instructed by their manager to do something, then if they do it, that is surely part of their work. Moreover, that is so even if they might not have been, if they might have been entitled to say that that's not something I'm obliged to do. I appreciate that Mr. Justice Lander isn't an employment lawyer, but of course the core employment duty is to comply with the lawful and reasonable instructions of your employer. So I'm not sure you're ever going to find yourself in a position where you can just say no, but one takes the point. Two, the same is likely to be the case where the manager does not instruct, but requests or encourages the employee to perform the activity in question. On the other hand, in such a case, it may be relevant to note for the expert's benefit, if that is the case, that the employee could not be required to perform that activity. Three, where an employee does something which they have not been instructed, requested, or encouraged to do, it may still constitute work if, for instance, A, it's simply a way of doing something which forms part of their work, and or the manager knows that they are doing it, but does not object and thereby tacitly approves of their doing it. So far that covers, I think, what the points I put to you. And four, they say, on the other hand, something may not be part of an employee's work if they have not been instructed, requested, or encouraged to do it. Their doing it has not been approved by their employer, and it does not simply constitute a way of doing something which forms part of their work. So that's where he draws the boundary.
Out of curiosity, we shouldn't ask this question, but I wonder whether that reflects council submissions, or whether Mr. Justice Lavender came up with this himself. Anyway, it doesn't matter. He had
given very
of course,
considerable.
he had good counsel for claimants, that's saying, but also for defendants.
Good, but ultimately hideously unsuccessful counsel for the claimants. More successful is now Mr. Justice Linden. And in partial answer to your question, one looks at paragraph 31, this point about requirement or expectation, that he was the source of that. So it says another relevant consideration is whether a particular activity was a requirement or expectation. This was a term used by the defendants, but Mr. Linden denied the suggestion that he was seeking to elevate it to the status of a test for what constitutes work. But nevertheless, what Mr. Justice Lavender does is identify, firstly, that a requirement is whether there's a requirement or an expectation is a relevant consideration to be taken into account. And I come back to what is said at 3.5 in Tesco's skeleton. They say the activity in question must be capable of being considered work. However, the boundaries of that concept, and that's the question that Mr. Justice Lavender is looking at, specifically that boundary, are not defined by the requirements of the employer, whether in principle or in practice. So their position appears to be, insofar as Mr. Justice Lavender might be suggesting you do look at the requirements or expectations, that's wrong. But I ask first rhetorically, how else are you going to draw that boundary? How else are you going to decide what the employer is paying for if you don't look at what the employer, broadly speaking, expects or requires? So employers are going to differ. Some will be absolutely clear what they want, and any movement away from what they've specified will be punished. Others might give you a task and leave it up to you as to how you go about it, at which point they're taken, I think, implicitly to accept that providing you're not swinging from the rafters of the warehouse in the way I've described, you're doing the work. But you're doing the work as just as Lavender describes, in a way which is a way of doing it to which the manager does not object, and that will also count. But all of that stuff, and in particular what is said at paragraph 4, is all really implicitly based on this notion that when you're deciding what work is, to quote the Employment Tribunal, it's the employer that decides ultimately what work is, and not the employee. The employee can't simply say, well, that's very interesting that you want me to do this task, but I'm going to do a different task. Or thanks for letting me know how you insist I should do this, but I'm not going to do it that way. I'm going to do it my own way. Ultimately, it's for the employer to identify what the work they're paying for is, either explicitly or implicitly. So that's why I think we actually disagree with Tesco about what the law is, because that these are passages that we set out, or passages that we paraphrased in the note. That notion that there's an employer expectation or requirement simply can't be hosed clean from the question of what work is. In some cases, it's going to be very strongly influential. In others, it's not going to be very strongly influential. So the risk of prefacing on what is 2 sub-grounds away from where I am now, in objecting to the tribunal's reference to employers' requirements and phrases like it's for the employer to define the job, it seems to me that the tribunal isn't going wrong, but also in any event, what weights to give to the question of requirement expectation, once it's identified as a relevant factor, has to be for the tribunal. It's its job to decide how much weight it's going to give it, unless it's perverse. So when we come to these sub-grounds, we think they're really perversity grounds, not described in that way. When it's said too much, they relied too heavily on the training materials, for instance, which is sub-ground C of ground 1. That's a weight point.
Yeah.
And that's got to be a matter for the tribunal, unless it can be said with a straight face that no tribunal would have given the materials that weight. So again, to anticipate, but hopefully shorten when I get there, what I'm going to say in relation to the training materials, once the tribunal has decided that they're going to start with the training materials, give them that weight of a kind of presumptive correctness, absent cogent evidence to the contrary, that is explicitly the tribunal according weight to a factor everyone accepts is relevant, absolutely a matter for them, unless it can be said with these training materials in this situation, they were not entitled to take that approach. What that would really require, I think, is for Tesco to have attended in front of you and said, these training materials are horrifyingly inaccurate as a description. No one should be placing weight on these training materials. They're obviously an unreliable source of information. But they don't say that, and they can't say that. Not least because it would be absurd on its face, but also because they use the training materials for precisely the purpose of testing the oral evidence, as you'll see. So unless they can go that far, which they explicitly do not, it seems to me that what we're really faced with is the tribunal having reached a decision which you might think is surprising in some respects, may even be wrong in certain individual instances, in the real sense of having been perverse, having taken something into account that they shouldn't have done. But as a matter of general principle, we must be entitled to look at these matters and say, these all arise out of the proper, ordinary, we thought uncontroversial definition of what work is. We don't interfere unless we are satisfied that they've gone past the perversity limit in some way. So that was took rather longer than I promised you I would take.
Sorry to interrupt you, Mr. Jones. Somebody yesterday mentioned the number of pages of training documents that the appellants referred to in the tribunal, I think. Can you? Is there a figure? Can you?
No, I can't give you a figure for the number of pages of training documents they referred to.
Yeah.
Because that will be an enormous number, and no one I think has ever calculated it.
Right.
But what they wanted to do, surprisingly, given the arguments they're putting before you in this hearing, is annex to their EVJD training materials.
Right.
So they wanted to incorporate into what they say would have been the proper way to approach the finding of facts, documents which set out training,
Right.
including an enormous document that described down to which button you pressed in which order the operation of the arm-mounted computer.
Right.
And that does have a number associated with it, and taking it from my closing submissions and assumed we counted it correctly, there were 198 pages.
Right.
So not 19,000, I accept, but 198 pages.
No. Okay. That's helpful. And as you say, they referred to training documents and cross-examination as well.
They did.
Okay. Thank you.
So I'm going to try now, to keep my promise to you and take you to the critical bit of what the tribunal looks at. So could we please look at tab 18 of the core bundle. And at page 284. So we're in the second judgment, and this is the first judgment in which they seek to make findings of fact about the work that individuals actually did. And you see it, paragraph 8. Sorry, Melanie, have I got to...
No, it's my fault for being an idiot. Picking up the wrong button. Thank you.
You'll see paragraph 8 that their minds have not been idle between the two exercises. They have had a number of opportunities to reconsider their understanding of the law expressed in their judgment of that date. That's the first judgment, the 12th of July 2023. So they took those opportunities, and confirmation bias, I suppose, has had its effects, and they have decided that they were right all along. They then, rather than simply assert it, set out what they say the legal principles are. So paragraph 9 is the starting point of their further explanation. They say the most basic principle of all is this: an employee's job is not what the employee says it is, but what the employer says it is. So that's the proposition I put to you a few moments ago, which we say is right. The employer requires the employee to do work, and the employee is required to do that work. Putting it slightly different, in a slightly different way, the employer agrees to pay the employee for the work which the employer requires. So that's the point that Lord Justice Nugee raised early on. Is it about what you're paying the employee to do? That's here what they say. If the employee does not do that work, then the employee is not doing his or her job. So that's, as it were, the loafing point, or loafing would be an example of that point. You can't simply not do your job and say, well, my job has changed. And then they also say, if the employee does not do the job well, then albeit to a lesser extent, the employee is also not doing his or her job. So I think that's technically true, but our argument in front of the tribunal, and there's no indication we say that they depart from that, is that it doesn't affect ultimately the value. So it's still work even if you're doing it badly. They say,
all right, but they put this right up as a guiding principle. That's the first point where you are not enthusiastically endorsing that formulation.
well, save that they then go on, I'd say, to clear the ball off the line, as it were, in the next sentence, where they say, the employee cannot, by failing to do his or her job or doing it badly, change the nature of the job. And that's the point that I endorse entirely. So you
got to
can't
read the
stack
two
badly and
sentences
say,
together.
my job is now badly stacking cages.
Yeah.
Only if the employer agrees to the employee not doing the work in the manner required by the employer, will the employee be able credibly to say, both generally and in our view for the purposes of a claim for equal pay for work of equal value, that his or her work is now to be done in that different manner. So it's saying may change, but it will only change effectively with the explicit or implicit consent.
So that is a cruder version of Beale, is that right?
Yeah, I think so. We'll see in this section they set out Beale and they adopt Beale. So we say, since we say Beale is right, they take the correct approach. There is a kind of uncertainty in this case, or something which, Mr. Justice Stacey says, requires some explanation, which is why they think they're disagreeing with us, because we think they're applying the rights test. But they obviously do think they're disagreeing with us. If you look at paragraph 10, they say, why then did the parties focus exclusively on oral evidence? So we say in our own defence, well, we didn't. Yeah, we put training materials into the bundle. Indeed, when we were drafting our EVJDs, we made reference to the training materials to identify what we said the job was.
Well, they may have slightly overstated it, but why did you, as you yourself told us 10 minutes ago,
yes,
basically take the oral evidence as the starting point and just test it or check it or elucidate it by reference to training?
we started with, yeah, with, now regretting because we've gone the other way, but we took the view that the starting point should be, certainly from our point of view, that the claimants would come along and describe their jobs. And if there was going to be a dispute between them and Tesco as to what they did, it was going to be essential that the tribunal heard from them and it had credible evidence in front of them upon which it could rely. So from our point of view, it was always going to need both kinds of evidence. And once you've decided that it needs both kinds of evidence, once you've decided not simply to say, here are the training materials, read them, and then run the risk that Tesco would field witnesses who would say, barely recognise this document, can't imagine how anyone thought this was how to describe the work, then the way in which any trial progresses is you hear from the witnesses, and then documents are put to them, and if you've got submissions on the documents, they tend to be made at the end. So I don't think we elected exclusively for oral evidence. I don't think Tesco elected exclusively for oral evidence, but it's pretty plain the tribunal thought we did. I can't read their minds, and it would be speculation if I tried, but I'm going to do it anyway, which is, I think, as I described earlier, they found the training materials when they looked at them so helpful that they thought we had been unhelpful in not taking them straight to it.
Not sure that's really speculation. I think that leaps from the page.
Yes. So they set about speculating as to what was in our minds, and they say, by the time of writing these reasons, this is still at paragraph 10, we could see that it was probably because of what was said in Shields about the need to look beyond what was in the contract of employment and see instead what was in the contract, what the employees, the claimant and the comparator actually did. So they say, we think the parties have tripped over Shields, so they then go through Shields at 11 and 12, but at 13 and 14 is where we get to the point of, we say, a particular significance. So as they run through the numbered subpoints in 13, they're explaining why they think Shields isn't a particular help to them. They say at 13.2, the respondent does not rely on any substantive provisions in the contracts or the employment of the comparators as a justification for the higher rates of pay. Then they say at 13.3, what was going to be needed to be decided by us, so this is them setting themselves the task, was what were the tasks which the sample claimants and comparators were required to do by their employer. So we say that's really a single sentence statement of the compound test I identified earlier. What are the tasks? Are they required? That's might not put it quite that way myself, but I think that's what they're looking at. So they come on to say, if there had been no documentary evidence in existence showing what were the tasks which the sample claimants and their comparators did in the course of their work, then only oral evidence could have been put before us about those tasks. But they say, this is where they come to their view of the significance of the training materials. They say, 13.5.1, However, in this case, the respondent is a very large employer, which, first subparagraph, operates in a highly regulated environment, which includes strict criminal liability for the sale of food products, and, summarising the situation broadly, have exceeded their shelf life or are contaminated. 2, uses sophisticated digital stock control and related systems. And 3, has in place an extensive and detailed set of training materials for use in training employees to do the work of the claimants and their comparators. So then just pausing there, those are all findings of fact. And as far as I'm aware, findings of fact which are not subject to appeal. So all of those things are things that the tribunal has determined as a fact. They go on to say at 14, those factors mean that, and then at 14.1, the respondent had a strong business need for the work of the claimants to be done in the same way throughout the respondent stores. Again, a finding of fact, which again, as far as I'm aware, is uncontested and certainly doesn't seem to be an issue before you on appeal. So those findings of fact, you will immediately anticipate, are the ones which point towards the training materials being reliable in this case, because there's a degree of standardisation, because they're subject to legal duties, which means that they have to do things in a particular way. So at 14.2, they say the training materials, stating how that work was to be done, were going to be determinative of what the respondent required the claimants to do, unless there was cogent evidence before us to show that one or more aspects of those training materials was not or was no longer determinative. So in the light of the findings they've made directly above, they say this is the approach we're going to take, which is effectively to prioritise the training materials. We will rely on the training materials unless there is cogent evidence to persuade us that they are not accurate. So it wasn't really a point developed in front of you, but there was some suggestion that cogent evidence was setting an impossibly Olympian standard for evidence, but we think it literally just means cogent evidence. No tribunal should be reaching any finding on the basis of evidence which is not cogent. It just has to be. And we'll see in a moment the way they do it, where they deal with it. It just has to be evidence sufficient to persuade them that the training materials in a particular case are not accurately describing what happened. But what they're not doing, on the face of it, is saying that there is an absolutely irrebuttable presumption that if the training materials say X, X is what happened. And they are explicitly not saying that. They are saying in terms, we'll look to see if there's cogent evidence. That's the contrary. And one of the reasons why that's significant is you could be shown hundreds of examples in which they say the employee said this, the manager said that, but we relied on the training materials. They're entitled to do that if they are not satisfied that the evidence that's been put before them is sufficiently cogent to displace what the training materials say. That's a matter for them. That's an allocation of weight to different kinds of evidence. And it's that finding of fact, or those findings of fact, I should say, that explicitly underpin then the approach which is taken at 14.2 is what we say, and what Mrs. Justice Stacey accepted from us, is an appropriate way of dealing with the questions that they then go on to describe. So it could have been the situation in which when they looked at the training materials and they looked at the evidence, they decided the training materials were unreliable. But that's not. That's not what Tesco said either. So Tesco, as we'll see, took we think, an ill-founded approach, but an approach of principle in which they said training materials are only going to be relevant if you had that particular training. And we say that can't be right. It can't be that you have two people replenishing the shelves on the same aisle in Tesco, and one of them attended the training the day before and the other's not doing it for 3 weeks. And their jobs are different. The work they are doing is different in those circumstances and has a different value. That obviously can't be right. This material tells you what Tesco thought the job was, what the work was, but unless they were able to say, which they didn't say, unless you've had this training, we actually required you to do something different, you don't need to decide whether or not someone had had a particular piece of training in the form in which it's looked at. Really, and there were two reasons why that was particularly important. One of which was that some people had training on the job. So there's no suggestion they're not being required to do the same thing, if they've got their training a different way. The other problem was, for someone like Mrs. Worthington, Tesco had not retained the training records. So the way in which they approached it is, as we'll see, we asked the tribunal to order that they should disclose the training that they would expect people in the claimant's positions to have had leading up to or during the relevant period. They disclosed it, that's what all the training material is. But when we sought to rely on those training materials in the EVJD for Mrs. Worthington and said, well, this is what they would expect to receive, they said, they crossed it all out and said, well, she hasn't received that training, you can't prove she's received it. Happily, we can prove every bit of training the comparators received because our records are better in the distribution centres. But alas, from your point of view, the claimants face the difficulty that we don't have, and particularly in Mrs. Worthington's case, any record of the actual training that she received. So fewer points for her because she can't prove that she's received the training. So again, I hope that will shorten some of what I have to say later in relation to ground 4, because that's the essence of ground 4, their suggestion that you really ought to be making findings as the tribunal as to specifically what training someone has received. Anyway, to come to an end bring to an end this first part, the EAT understands what the tribunal's done, and it doesn't stick criticism, but if I can invite you please to turn to tab 11 of the core bundle, to page 117. You should find there paragraphs 90 and 92. So I invite you on, if you've not read them already, to read the whole of 90, paragraph 92 to the end of the section. But what I'm going to invite you to focus on at the moment is at 118, 7 lines down, you should have a line which begins note to assist the tribunal, which is referring to our joint note. And then you'll see that the EAT says this. But my reading of the tribunal's conclusions from its discussion of the case law.
So sorry, which paragraph are we in?
You're in paragraph 91, about 7 lines down from the top of the page, at page 118.
Yeah, sorry, I found it. Yep.
But my reading of the tribunal's conclusions from its discussion of the case law is that it has clearly read and cited the leading authorities, understands the importance of Brunhofer in its entirety, and expressly stated that it was following Brunhofer. It set out the law in laborious detail. The tribunal's focus on Beale, quoted at some length by the tribunal, explored the boundaries of what constituted work. So the EAT has recognised that that's the point the tribunal has fixed on, the question of the boundary of what's work. Within the confines of the established case law, memorably coined the loafing test as an example used to describe, quotes, something that may not be part of the employee's work, if they've not been instructed, requested or encouraged to do, their doing it has not been approved by the employer, and it does not.
Yeah, I mean, I don't think this matter. That's not really quite what the loafing test is it?
No, but it's part of the, I think.
Loafing's a bit of a red herring in a case like this.
Yeah.
Loafing is what you do about the person who says, the employer who says this guy's work isn't worth very much because most of the time he's sitting playing cards. But that's not an issue here, really, is it?
It isn't.
No.
It's really, I think, fixed on by Mr. Justice Lavender as being the clearest possible case to support the proposition that you can't simply rewrite your own job by doing or not doing something you're supposed to be doing. And to be fair to Mrs. Justice Stacey, that's the point she picks up at 92. She says the point being that if an employee is in practice loafing about all the time, and that is not behaviour condoned, known of, or encouraged by the employer, it does not become part of the employee's work. And just because that is what in practice he is doing. But in concentrating on Bill, the tribunal did not inadvertently lose sight of the basic principles. Thus, when the tribunal stated in the CMO that it was important to focus on what work the employer in practice required persons who were in the role of comparator to do, rather than the way in which the comparator actually worked, the tribunal is doing no more than referring to what was memorably described during the course of our hearing as the loafing limit, but understood in the rather more subtle way that I hope I put it this morning, not simply are they loafing or not. The loafing limit marks the boundary between work and what might in other contexts be described as a frolic of one's own, or doing something that might elicit a response from an employer when they find out what the employer is up to of, and to come back to Lord Justice Nugee's point, I don't pay you to, e.g. loaf around all day, but to get on with work in the way I've told you how to do it. Now get back to work.
And her reference to what might sound described as a frolic of one's own slightly plugs in more to the way I was preferring to put it, which is what you're doing voluntarily. Yeah.
So I think the tribunal under this appeal tribunal understood what the tribunal was saying, albeit that she's critical about the hyperbolic way in which it is sometimes put, that they're not always quite consistent about the way in which it's put, but they get to the essence of the test in the way in which I have described it. And in terms of the key finding, lady, you asked me where did the VAT mention it. They deal with it in a separate section of the judgment when they say which overlaps with some of the issues here. That's at page 139. Paragraph 165. This is where they're dealing with what is now ground 4. You can see that at 138 there's a subheading. Refusing to make findings about training received by job holders, save in relation to forklift truck training. If one starts at 139, page 139, and at paragraph 165, at the end of the third line, they say this ground has some overlap with A1G2. Read in isolation.
Remind me which A1G2 is.
So that's too much reliance on training materials. They go on halfway through the paragraph, roughly where, just below where the first whole point should be, if I wasn't looking at an electronic document. The tribunal concluded that on the particular facts of this case, and given the nature of the respondent, the strict requirement for everyone to follow and apply all the training materials to the letter was what the employer required the sample claimants and comparators in practice to do in fulfilment of their duties, unless there was evidence to suggest otherwise. You can see that what she's doing there is referring to 13 and 14, the passages we looked at earlier. The strictness of the requirements that the employer has, and the fact that that leads to the conclusion that they would rely upon the training materials unless there was cogent evidence to the contrary. She says the tribunal spent some time explaining how training was delivered, and much of it required employees to read it themselves and watch the training video, following the manual and such like. And the obligation seems to be on the employees to make sure they are up to date. The first judgment, which also has to be read in the context of the preceding paragraphs, to gain a full understanding of how the tribunal arrived at its conclusion. Part of the context of the tribunal's conclusion is the undisputed evidence that much better records of training was kept at the DCs than the stores, which could have inadvertently unfairly disadvantaged the claimants and presented a distorted picture. So 2 points. One, the EAT is acutely conscious. We say the finding which has been reached at 13 and 14 in the second judgment. That's the findings we say that she's referring to. And then in the final sentence, she's also conscious that the tribunal was conscious that there was an issue about a sort of what we called an asymmetry of information. That the employer has available to it information which the employees do not. The employer doesn't produce that information, it puts the employees at a disadvantage. And it's obviously, we say, incumbent on the tribunal to avoid that disadvantage in a case of this sort. So, unless I can help you further on that, general approach. I hope now to be able to move through the more specific grounds. I hope some pace. But the first specific ground was, did the tribunal focus on generic jobs? I start by saying, conscious of the irony, it's important to look at what the tribunal actually did and not how they defined their task. We don't think there's much of a gap between them. So what do they actually do? Our starting proposition is this: if the tribunal had fallen into the error which is being described by Mr. Reed, and they just said, who cares what the individuals are doing, what we're looking to do is make findings about generic jobs, the individual evidence is only ever going to be relevant insofar as it informs that question of what the generic job is. So if you found yourself in a position where you, as the tribunal, where you found that the employee was doing something which very substantially departed from the generic role identified in the training materials, you'd only be interested in making findings on that if you were going to go on to make a finding that what they did was typical. In other words, that it's helping inform your decision as to what is generic, and not make findings about what the individuals actually did. So we can test that with a couple of examples. The first is, first and second relate to Janice Cannon, and she was a customer assistant at Knights, was her role. And if I could invite you please to look at the second judgment in tab 18 of the core bundle, we're going to be going to page 460. This is Appendix 4, the sum of Appendix 4 to the second judgment, which deals with Janice Cannon's work clause. Just pausing here, you'll see a paragraph at the beginning which is in bold and capitals. It says, the tribunal's determinations of the parties' disputes in relation to the work which Miss Janice Cannon, to whom we refer below in this appendix as the JH, which is the job holder, was employed by the respondent to do, and two, in relation to the other factual matters which are relevant to the issue of what was the value of that work for the purposes of section 65(6), and the open brackets mainly job holder specific reasons for those determinations. So we say the tribunal is clear what it's going to do. It's going to try and resolve the disputes, so it's not abandoning that job. Explain that how it's going to go about it is by focusing mainly on the quotes job holder specific reasons for the specific determinations. So let's see them do it. If one looks at 484, you can find paragraph 94 there, and they say this: the dispute in regard to paragraph 142, so that's a paragraph of our EVJD, is concerned essentially the frequency with which the job holder replenished shoes and handbags on display. We saw that the way in which the job holder did the job of replenishing those things was inconsistent with what is said at C4/1910. So whenever you see a C reference or a D reference, that's a reference to training material about being able, quoting, to run the warehouse operation with no blue trays. So let me just explain what that means. When deliveries came in, goods would be in trays of different colours. And one of the colours was a blue tray. If I remember rightly, that was menswear, but so on the face of it, not going to include handbags. But they came in delivery boxes. And what the training, as we'll see, because they set it out required, is you didn't just wander onto the shop floor with the delivery box. You put everything onto a rack, and then you moved the rack onto the shop floor, and you replenished stock from the rack. So they say, if she used the quotes equipment in the warehouse effectively, which meant using cages for footwear, and as stated at the top of C14/1911, so yet another piece of training, high-level trading rail storage for footwear and bags. In addition, it was said at C4/1915 that any essentials, footwear, bags or accessory stock that was stored in a warehouse on movable fixtures should be pre-sorted directly onto back stock, and that the best practice for filling from rails is to pull the whole rail onto the shop floor at set times during the week, through the week. That will be dictated by how many times you need to fill to keep your shop floor full. In addition, further reference to training materials, it was said that no product should be stored in blue trays. However, given that the respondent did not object to the way which the job holder did the things described in paragraph 1.2, we concluded that it was approved by the respondent. So it became part of her work for the purpose of section 65(6) of the Quality Act 2010. So here is a clear example where they say, this is what she's doing. It's not what the training materials suggested she should be doing, but there's no objection from the employer, so there's that condoning that's described in Bill, therefore that's her job.
Just for context, why is this significant to the level of demand, whether you fill from rails or not?
Well, we don't know whether or not the independent experts are going to think it's significant.
Yes, I see.
But in essence, the essence of the dispute, as I recall it, is we said she was doing this role more frequently than Tesco said she was doing it. So the more often you do it, in theory, the greater the demand. But it's
Anyway, okay, I don't want to get bogged down in that. Your point is it's an example of them fighting against the training manual.
yeah. So if their plan was what's generically required across the entire Tesco estate, they shouldn't be doing this. These are not questions that they should be asking themselves. There's no point reaching a finding, and there's no point including that finding in the EVJD, so that it's then sent off to the independent expert to assess. So there's a second example in relation to her, which is at page 453.
If it's 453, it can't be her, can it?
We
She had two appendices.
There, she has two. So it's slightly oddly done. So she has two. The comparators have one between them. The reason why she has two is because the tribunal's approach to how it was going to make findings of fact evolved as they did it. So starting first with Mrs. Worthington, she's dealt with in one way. They then they then deal with Miss Williams in the same way. When they come to Miss Cannon, they decide effectively halfway through that they're going to deal with it a different way, but they leave both versions in. So you get Appendix 3 and Appendix 4, the latter
But
one being
ostensibly covering different disputes, so there shouldn't be any inconsistency.
in
between them.
theory. Yeah. And I certainly haven't had anyone identify as yet an inconsistency. So there's some introductory material which I won't take you to, but just to make the point, paragraph 80, you'll see, so did the assertion that the job holder would, as she walked through the F&F department, which is the clothing department, pay particular attention to the displays containing essentials to identify any gaps, refer to something that it was important for the IEs to take into account in deciding the value of job holder's work for the purposes of section 65. Was it, in other words, something which the respondent would have wanted the job holder to do as part of her work? And put like that, the answer was surely yes, it was, if only because it would mean that she would have an idea of what was required by way of replenishment. Did she do it? In our judgment, yes, she did. The evidence was given honestly, and she was a measured, careful witness. And this part of her evidence was about something that we thought would have been done by any conscientious and caring employee in the F&F department, which we concluded, having heard and seen her give evidence, the claimant was. We add that the assertion that the job holder looked around the department when she arrived at work could not credibly be contested by the respondent unless there was some concrete evidence to the contrary. But one, it would be hard to find such concrete evidence, and two, there was none put before us. So again, not on this occasion rejecting training materials, but again making a finding specifically about what she did, the way in which she did it, and reaching a conclusion. I think if we were going to classify it under Beale, that this is one of those occasions in which what she does is a way of doing the job. So she has developed her own technique, what we call gap spotting.
And it's based on her oral evidence, not
Based
the
on
training
her oral
documents.
So can I come then to I hope the last part of this ground, or almost the last part of this ground, which is the Wayne Jones example that you were given yesterday, just test that a little. You'll recall that what Mr. Reed said is, well, look, when we look at the way in which the evidence about what Wayne Jones did in terms of cage stacking is dealt with, here they are rejecting the evidence of the managers and relying instead.
Just so I can again get a picture of how it works in practice. You obviously call the claimants.
Yes.
In this case, Mr. Jones didn't give evidence. Do you, although in a sense the comparators are chosen by you and a part of your case, are they in practice called by you?
No.
So in the respondents call the managers.
Yes.
Or the individual comparator when they're willing to give evidence.
So they did both.
Yeah.
So there were a lot of witnesses. And in terms of the challenge that we faced, of course, none of the claimants work in the distribution centres. So it was the most obvious case of, as it were, informational asymmetry. What I'm about to take you to is the fact that the witnesses that they produced had a rather torrid time, and the tribunal reached some pretty clear conclusions about the credibility of the evidence that was put forward. Now, I know you've read the judgment, so you may recall what the tribunal had to say. But I'd like, if I can please, to take you to Core Bundle tab T16, page 247, which is the first judgment.
So now this is volume 1.
Did you say 347?
247. In fact, 246, I think we need to start at. Sorry, my fault. And may I invite you, please, just to read paragraph 56, which sets out an extract from our closing submission. So those were the submissions. About 10 lines up, 9 or 10 lines up from the bottom of paragraph 57, you'll see the tribunal says this. However, taken in isolation, what was said in paragraphs 24 and 25 of the lead aid claimants' written closing submissions, which the ones you just read, was entirely apt, and we accepted it. We concluded that the respondents' legal representatives had compiled evidence, at least in part with a view to supporting the respondents' intended submissions to this tribunal, and then asked the witnesses who were called to give evidence to us to approve a witness statement or statements, which was or were intended to support those submissions. Those witnesses had then felt obliged, if at all possible, to agree those statements in at least some cases they had not read them properly before doing so. So I accept that a judicial eyebrow might rise in circumstances where you find the tribunal saying, we've had evidence from a manager, but we're going to rely on the training materials. In ordinary circumstances. These were not ordinary circumstances. And I had, if I may, one more extract from the closing submissions to hand up, because it's relevant to this example.
Thank you.
So you should see the subheading, I stress again, affectionately referring to super Laing. And at paragraph 144, you'll immediately see some material in italics which set out the Tesco's case. So it's contended that Mr. Jones had developed different and more skilled methods of work than those taught in training, and which are deployed by most other warehouse operatives. The contents of his work is to be assessed in relation to what he did, not what other warehouse operatives did, i.e. taking into account his skills and methods of work. We'll see in a moment that the manager witnesses that were relied upon by Tesco included a Mr. Matthews. You see the submission goes on to cite something which was an exchange in the transcript and cross-examination. Mr. Matthews had to accept that his witness statement had been prepared before he even observed Mr. Jones' work. So the question, and all of your confident assertions in this witness statement about what he does was done before you'd actually gone to watch him. Answer, correct. So, no doubt, and you will anticipate, his position was, and when I did go to observe him, it turned out that it was exactly as been described in my witness statement. So we're not suggesting that they didn't stand by their evidence, at least in this respect. But what I would say is the tribunal, in approaching the question of what Mr. Jones did, knew this, whereas when you heard from Mr. Reed yesterday, you didn't know this, and you might not perhaps have had at the forefront of your mind the really excoriating comments that the tribunal had made, as they were entitled to, having heard the evidence from the witnesses themselves about the credibility of the witness evidence before them. I should stress that at one point I think there was a question as to whether or not the respondents were going to appeal credibility findings, but they ultimately did not. So those findings in relation to credibility are not an issue. So why does that matter? Well, it may be obvious why it matters, but if one looks at page 251 in the second judgment, which is at page
Second judgment.
Which is at 7:30, and page 7:30 at tab 18. I think.
Sorry, which page again? Sorry.
At 7:30. 7:30.
Yes.
So paragraph 251, they say for the avoidance of doubt, said in paragraph 6.123 of the EVJD from Mr. Jones, and then they quote it, the stacking of multiple different unit types into individual cages was more difficult than assembling into slimline cages, given that these cages were narrower. This meant that the practical difficulties of having to stack units of different shapes, sizes and weights were exacerbated. It was directly contrary to the passages that we have set out in paragraphs 58 and 60 above. So you'll recall Mr. Reed said, look, here they are. I'll take you to 58, 60 in a minute, and I'm going to do that too. I'll ask you to bear the number 60 very much in the forefront of your mind. Those are findings about what was said in training materials. So here they are overruling the managers by reference to training materials. They go on to say the latter, in our judgment, were rather more reliable than the oral evidence of Mr. Evans in paragraph 442 of his witness statement and Mr. Matthews in paragraph 103 of his witness statement. So the tribunal here is doing exactly what it's expected to do and what it's entitled to do, which is to say we have compared the oral evidence we've had from the managers to the documentary evidence, and we think the documentary evidence is more reliable than the witness evidence. So that is not a sign that they are going astray or that they are doing something unexpected or something beyond their powers. It's literally their role in finding facts to decide which bits of evidence they prefer. So I said I'd take you to 58 and 60. That's at 681 in the same bundle. And then they refer to training materials that relate to stacking. So you'll see at 58, a quote from a training document which says, "We pick products to suit the store layout." And that means the shop, the store, not the warehouse. It means that when a colleague takes a cage dolly out onto the shop floor to stock the shelves, everything in the cage or dolly is for the same aisle. If we have not followed the AMT, that's the unmounted computer, exactly, it results in our colleagues having to restack cages and move from aisle to aisle stacking shelves. Or worse, we haven't picked all the stock requested and our colleagues don't have anything to put on the shelves for the customer to buy. So in the context of Tesco's case being, we indulge Mr. Jones because he's so good at what he does that we don't trouble him with putting the right boxes into the right cages. The training materials made it clear that this wasn't just a matter of convenience, that the system itself was designed to make sure that the right things ended up in the right aisle at the supermarket. And if you'd had a chance to read through the elements of the closing submissions that I handed up a moment ago, you'll see that's one of the points that we were putting to witnesses and one of the points we invited the tribunal to rely upon. Also, so you see that it's about halfway down paragraph 145. It says it would potentially result in the cage weights being wrongly recorded and make life harder for stores by splitting products where they were required to replenish across different cages. Above it, you'll see we're making a further point, which is the one that I heralded earlier, which is that if you put things into the wrong cage, you've got a cage error. And you'll recall I said that one of the matters in evidence was that Mr. Jones, rather than being passed on the back for his inaccuracy, had been subject to disciplinary proceedings for his inaccuracy. So these, again, are all things that the tribunal has in mind. And one of the things they're entitled to have in mind is at 58 and at 60, the training materials saying don't do what Mr. Jones does. Follow the AMT. So at 60 they say the system knows what stock will fit in a cage at the start of the pick. That is why it's important that we follow what the AMT says and ensure the right stock and the right amount of stock goes in the right cage. Otherwise we end up with the cage we saw at the beginning. I don't know quite what that is, but I'm imagining a badly stocked, badly stacked cage. Grocery, if there are any issues with the cage, it will be telling you to put too much in, ensure you tell a manager, as it may be a system issue. So, tribunal doing what it is entitled to do. But there was one more point you remember that Mr. Reed made. He took you to paragraph 66. He said, well, bafflingly, here is the tribunal making reference to some additional guidelines, but those guidelines don't relate to ambient warehouses, which is where Mr. Jones worked. They relate to fresh warehouses, and he didn't work there. So here's an example of the danger that if you allow the tribunal to wander its happy way through the training materials, they may end up taking into account material that's not relevant. But you may recall a few moments ago I asked you to bear the number 60 in mind. What they say later in the judgment is, they do later in the judgment, is cross-refer to paragraphs 58 to 60, not 58 to 66. They don't cross-refer to this paragraph in reaching their decision. nor is it odd that it's here in Appendix 8, because Appendix 8 is not Mr. Jones's appendix, it's all the comparators' appendix, some of whom work in a fresh DC. And even if all that were not an issue, even if it could be established that they had taken this specifically into account in relation to Andy or warehouse, what's clear is at 66 is that they know this is a fresh assembly piece of training, because they make it clear that that's what it is. They say there were similar guidelines by referring to fresh assembly. It wouldn't, I think, be an error for the tribunal to say, we've looked at the material which relates specifically to the ambit warehouse. Here is some similar material which relates to another warehouse.
Which emphasises the importance of doing it in the way that you're told to do it in the ambient warehouse.
Correct, entirely correct. So, pausing there, have they approached this task on the basis that they're making findings about generic jobs? They have not. Have they relied on training, which describes a generic job? They have. But they have, in the examples that I have given you, I hope, done so for the purpose of making specific findings about what the individual job holders did. So the short point is, I say cheekily, having taken so long to make it, the criticism that's levelled against them simply isn't what they have done. The EAT, of course, went through the exercise of reading the judgment as a whole. And the EAT reaches the conclusion that they haven't done that either. The EAT's finding, which is appealed here, is that they have set about performing the correct task. I'll take you in a moment to specifically what the EAT said. Now this, I mean, hopes that I don't have to, unless you want me to, go through the individual paragraphs which have been picked out of the judgments by Tesco, what the EAT describes as the slim pickings, to justify to you that when you look at those paragraphs, they're really talking about the compound test that I identified earlier, and that they're not slipping into the error of making generic findings. I'm going to chance my arm and just treat myself, as it were, to two. One is at page 286 in the second judgment, 13.3. So you'll recall this was one of the critical findings that we referred to earlier, and where they identify their task, and it's an example of where Mr. Reed says they've gone wrong. So,
Sorry, which bundle?
so this is the first bundle, sorry, the core bundle.
Core one.
Core 1, tab 18, page 286.
It's called 2.
I'm so sorry, I'm working from it electronically.
So page 286 in
Page 286, paragraph 13.3. This is one of the instances where Mr. Reed says they go wrong. They say what was going to be needed to be decided by us was what were the tasks, and now I emphasise, which the sample claimants and their comparators were required to do. So this is not an example of them saying we're going to adopt a generic approach. They are literally saying we're going to look at the sample comparators and the claimants do. I invite you, I treat myself to two, I invite you to take some care when you read the passages which have been set out. So one of the other examples, and I think if I remember rightly, the AT says what was relied upon is Tesco's been one of the clearer examples, is the text of the July case management order. And you'll find that, I think, in Core Bundle 1, tab 17, page 265. dealing with paragraph 11, which runs over onto page 266. And the passage which is cited by my other friend in his skeleton says, has the tribunal saying that paragraph in our view showed how important it was in general to focus on what work the employer in practice required persons who were in the role of the comparator to do, rather than on the way in which that comparator actually worked. So there is, it's very clear here, they're saying it's all about what the role requires and not about the way in practice the comparator works. So breaking that down, firstly, so far as the way in which the comparator actually works, it has to bear in mind that this is the tribunal again distinguishing between.
So sorry, I haven't quite got which passage you're in this, which paragraph in this you're referring to.
So I think it's paragraph 11.
Let me just quickly read that.
So it's the very last line at page 265. Halfway
I see.
along that line.
This is quoting me. Yes, so basically you say that's, as you explained in your first hour, that's not unorthodox.
No, and more importantly still, the next sentence says, of course, if the comparator worked otherwise in accordance. So even if you could read that sentence as saying we're committing to assessing generic jobs, in the very next sentence, understandably not cited in the skeleton at that point, they move on to refocus on what the individuals are doing. Now, I accept that the employment judge may be seeing things in press that I can't see. But that doesn't affect the point that he's very clear that he's focusing on individuals. And then just concluding on this point very briefly, so far as the EAT is concerned, although we think it's the correctness of the tribunal decision that matters, they, they again, and Mrs. Justice Stacey absolutely impeccably directs herself on the authorities in terms of how one should approach a judgment. She cites all the authorities that Tesco wanted to cite, UCAT and Brain, Anya and Godfrey, in that West Market, and also Crofton and Yaboa. So she understands and was very clear that she's not to comb through the judgment looking to stand it up. She is another one satisfied that it has been correctly determined. She's critical at paragraph 84 of her judgment, and I won't take you to it unless you now wish me to, that the tribunal has not helped itself by addressing the test more than once. But the EAT is correct to say that the judgments read as a whole reveal that the tribunal has not jettisoned.
I can't remember, I've actually got it in front of me. But there are authorities for both sides on all this. There's one saying don't pick through trying to reconstruct reasoning that really isn't there. There's another one saying read sensibly, don't pick on minor errors or errors of the speaking.
Indeed, I think
And does she refer to all of those? I can't remember.
Yes, well,
Where's her judgment?
so her judgment is in core bundle tab 9. Which will be the
Sorry,
first
I know
one.
what I really meant to be. Bit of her judgment will be on.
So you're at page 112, paragraph 76 to 79.
Yeah, sorry. Probably that up. Yeah.
So cutting what might have been longer submissions that's short, basically, I expect everyone feels. Paragraph 98 of her judgment, which you will find at page 121. Having properly directed herself, run through her analysis, she says at 98 there were slim pickings for Mr. Reed to construct an argument from the tribunal's enthusiasm for the crest and other essentially throwaway comments, it could be deduced that the tribunal had not considered the individual claimant and their comparators' work. The tribunal was focused on what the individual claimants and their comparators did in the 619 pages of the second judgment, which made reference to particular evidence and facts of each of them, albeit some were arrived at by considering training materials, as the tribunal acknowledged how the equal value conclusions on the sample claimants and comparators in the first of the three tranches would roll out to others amongst the 55,000 claimants was for a later stage. So the appeal tribunal, as it were, got it, and the appeal tribunal understood what the tribunal had done because it looked at the judgment, and rather than just at the bits that Mr. Reid wanted Mrs. Justice Stacey to look at, looked at the judgment as a whole, and thus saw examples of the kind that I've just indicated, and indeed we took Mrs. Justice Stacey to the Mrs. Cannon example, if I remember correctly. So that brings us to an end of that point, and I hope I have, in so doing so, quite a lot of what I said in the remaining matters. But with your permission, I'll move very briefly to look at round one, sub-round B, which is did the tribunal err by looking at what the employers required employees to do. And I can deal with that, I hope, more or less instantly, which is to say this is, I think, a matter that I've covered. It's clear from Beale that requirement or expectation may be a relevant factor. The tribunal was perfectly entitled to take this into account. The weight they gave it was a matter for them, unless the weight they gave it was perverse. It's not able to challenge your interview. However, plausibly, Mr. Reid can otherwise advance his case. And we have also already looked at the passage in the Employment Appeal Tribunal decision, which for your note is at tab 9, page 117. It's paragraphs 90 to 92, and you'll recall I took you to the end of paragraph 91 and the beginning of paragraph 92 to show that the tribunal understood that the appeal tribunal understood that what the tribunal was focused on was this work boundary issue, or as my Lord Justice Underhill pointed out, rather helpfully describing it as the loafing limit, whereas it's more complicated than that. But the EAT understood that the way in which the tribunal had approached it was to ask itself what's the boundary of what work is in the formulation, the work which people actually do. Did the tribunal err by placing too much weight on the training materials? This is subground C. And there is...
Before you do that, the tribunal, as I think the EAT says, doesn't help itself by setting up what, in the light of what you started with this morning, seems to me to be a false contrast between what the employee did and what they were required to do. Your point is, in the end, work is both what you do and does it count because it was part of doing your job?
Yes.
And you have to answer both questions.
Yes.
But the tribunal undoubtedly says, well, we're not interested in what the employee did, we're interested in what they were required to do, which is a very unhelpful way of putting it.
It is an unhelpful way of putting it. To be fair to them, as in fact was demonstrated in the passage I took you to a moment ago, they tend to say that, and then they say, but of course, if what you do is different, then we ask ourselves whether it's condoned. So they always bring themselves back to the appropriate test. But you're right, it's not one thing or the other. It's both things weighed together in the balance. And in practice, what we've seen is that's what they do. So when we looked at the example,
well, I don't even think it's right to say weighed together in the balance. That suggests you've got a bit of evidence which suggests this and a bit of evidence which suggests that, and as I understood your opening submissions, actually, for something to count as part of your work, you both have to do it, and it has to be a way of doing your job.
yes,
And so it's not weighing in the balance. It's you've got to meet two cumulative tests. If you're stacking a shelf, A, did you do it, and B, was it something you were meant to be doing? If you're supervising other people, did you do it, and was it something you were meant to be doing? And you have to meet both cumulatively. I think that's what you were saying.
I think so. I think, as it's not unfamiliar experience, it's a much better way of putting it than perhaps I had when I described it as a compound test. But you're right, these both have to be satisfied. So there's no good saying the employer required it if it's plain that in practice it was never ever done, unless it's because you're defaulting. So you have to look at the reality. The way we put it in front of the AT was to say, well, one very short formulation, so it suffers from all the potential exceptions and inaccuracies that short formulations do, but trying to capture the essence of it is the compound test, cancelling the fractions, come to what in practice does the employer require? What work? So what, if you ask what in practice the employer requires, it's not what does it theoretically require, what do the documents say? It's asking that question, has this been condoned, do they know about this, have they encouraged you to do this? It will cover that much broader ground. You're just asking, but you're getting both points in. There's a degree of looking at what the employer wants and requires, and that's one half of the test, in other words, as you've described it. And the other half, because you're focusing on the practice of it, you also must look at what happens in practice.
But
Those
I mean,
both must be
to
satisfied.
pick up what may be a false example about opening the egg boxes, it may be as clear as you like that the employer says if you're putting an egg box through the till, you have to open it and check none of them are cracked. But it may also be entirely clear that none of the till operators ever did that because they're under pressure to get the material through. And
I agree. And if the shop manager walks past them and doesn't challenge it, then
it's not part of your work, even though you're required to do it. That's why setting up what looks like a dichotomy between what you're required to do and what you do looks like leading you into error. And you say it didn't really lead them into error.
it did. So on your example, and one way of looking at it is the way in which Mr. Justice Lavender looks at it, which is to say there'll be some functions which fall into, and I love this word, desuetude. So it may be on the face of it a very clear requirement, but if in reality no one does it, no one asks them to do it, then you just reach a point where it doesn't realistically work anymore. So I agree.
Indeed, I'm old enough to remember when certain unions used to work to rule where they applied every rule in the rule book.
Yes.
And that ground things to a complete halt.
Yes. Yeah, a very clear lesson about being careful what you put, I suppose, in your rule books. But I agree. It's a two-part test. You have to satisfy both parts, and that is the better way, I think, of looking at it. And I think that for all the infelicity of the enthusiasm and hyperbolic nature of the way in which they put it is certainly where the tribunal ends up. And I think read with the degree of charity that they're entitled to, also really what they say. Once you understand that that's where they're coming from, what they've done is choose words which are capable of being interpreted, at least on occasion, in the way in which Mr. Reed wants you to interpret it. But that's detached from the reality of what they actually do.
Thank you.
So training materials, again, I hope I can deal with this relatively swiftly. Ask you to bear in mind this. What are these?
What you were doing helpfully was going through the four subheadings under one.
Yeah, so this is C.
C and D. Well, C is training material, I suppose.
It is, yeah.
Sorry, yeah.
So the argument is tribunal errs in effect by placing too much weight on the training materials. And there is the kind of ghost of a point that was taken below in the AT, where there was said to be a serious procedural impropriety in that the tribunal had changed its position at the last moment. And that survives, I think, in this formulation to the extent of it being an aggravating factor. They say, well, no one turned up prepared at the hearing to deal with the fact that you might be going to be relying on training materials. So I just want to address that fairly briefly. But it's important to understand what the training material we had was. And forgive me if I've taken you to this already, but if you look at what's described as the reference supplemental bundle, but has also been called the supplemental bundle simpliciter,
Or
That
core supplemental one.
It's not the core.
Not
it's
the
the
core.
other one.
The other one.
So
Okay.
In fact, everything that's in the core is also in the other one.
correct.
I can see why the judge thought it was a good idea to have a core, but actually it hasn't worked.
So I'm going to take you to the main supplemental bundle. Forgive me if it is in the core, but it's at tab 20, page 268,
Volume 1.
volume 1.
I'm so sorry, could you repeat the
Yes,
tab,
of course.
please?
It's tab 20, page 268.
Thank
We're going to
you.
be looking at paragraphs 8 and 10.
What is this document?
So this is the case management order, or a case management order, which was made by the Employment Tribunal. Forgive me, I don't have the date to hand, but it will be at the end of the.
Well, 265, it says 19th of December 2022.
I'm very grateful for that.
That's the date of the hearing. I don't know whether it was
273, it says
promulgated.
3rd of January.
Yeah, so it's promulgated on the 3rd of January, day 3.
Yeah.
Yes.
So you will see that my learning friend Mr. Bryan had made an application for training materials. So the first most simple point is it wasn't just give us all your training materials. Of course, we had to define what we were
Sorry,
looking
which
for.
paragraph are we on?
This is paragraph 8. The second order sought by the Harkers claimants was a statement of what training modules it, that being Tesco, would have expected a staff member in each sample claimant's position to have undertaken, up to and during the relevant period of the 18th of February 2012 to the 31st of August 2018. So that relevant period is effectively the training period. And 2, the provision of copies of those modules, if they've not already been provided. So it's, you can see why we're asking for this. We're not just saying training materials in the abstract. These aren't dangling training materials. They're the ones that, even if we can't say this is the training we actually received, it's the training material Tesco say they would ordinarily expect people in these positions to have identified. The respondent's objection is that some of the material sought was plainly inapplicable because it related to work which the relevant claimant had not done at the time the material was live. Mr. Bright makes it clear that the claimants are not seeking that material. So again, it's further narrowed. It's the material that relates literally to what the sample claimants were doing. And then they cite me saying it might be possible to deduce from the training what the which the claimants were given, what work they did, and the skills which were required to do it. And the tribunal says that was obviously correct and it was helpful, pointed out. So I have on at least one occasion been helpful to the tribunal. In fact, it's rather, if anything, slightly too narrowly defined, because this material may be, as I'm going to go on to say to you, helpful whether or not you've actually taken it. But the tribunal properly understood that we were saying, collectively as the claimants, and subject to that qualification at paragraph 9, Tesco were accepting that this material, the training materials, were relevant. And they were narrowly drawn to make sure that that relevance was maintained. Again, as I say, when we came to the hearing, this was material that we relied upon, and it was material Tesco relied upon for all purposes, for cross-examination, but also for submission. There were 2 matters which were raised by Tesco as a way of seeking to persuade the tribunal not to rely on this training material. So for present purposes, that has one particular significance, which is this, that live during the hearing was a contention from the respondents, the then respondents, that there was good reason not necessarily to rely on particular pieces of training material. So it's not a case in which the training material, as it were, loomed completely out of the dark after the hearing itself had come to an end, and they were denied a chance to say, be careful about the training material. They were saying, be careful about the training material. And they said, be careful about the training material for two reasons. The first is that their position was you shouldn't really place any reliance on it if the individual hadn't received the training. So they say, in effect, however accurately this material might describe the job of someone who has had the training, it's not a reliable indicator of the job of the work of a person who hasn't had it. And we say, it's just absurd, this proposition. And I could see there might be circumstances in which that were true. So if, for instance, particular training gave you a skill you couldn't possibly otherwise have had. But for the most part, replenishing shelves, moving cages about, the sort of stuff that people were doing on a time standard basis, it just doesn't make sense to say, unless you sat there in the room or unless you've read this bit of paper and taken the exam attached to it, that your job is different, that the work you do is different, any more than it would make sense to narrow it even further to say that when you arrive at your job at 10 AM, your job is one thing, and once you've read the training material, it says you must turn the cans of soup round so the label is facing outwards, that being something you already previously did, that your job has changed in a meaningful way. That the work you are doing, I should say, has changed in a meaningful way. So we didn't think this really made any sense, and the Employment Tribunal agreed with us. So at page 255 in the core bundle, at paragraph 79, they set out their finding in relation to that.
What's the paragraph?
It's paragraph 79, my lord.
In the first judgment.
No.
Second judgment.
First judgment.
Okay.
Sorry, so that's tab 16. So it might be helpful if that, I'm sorry to do this to you, but if you could read on through to the end of paragraph 81, that covers some of the material I'm going to look at when we get to ground 4 as well.
I'm sorry, I'm not even with you at the moment.
But that's my fault.
What's bundle number are we in?
So we're in core bundle 1, tab 16. Page 255.
Sorry, it's been a long morning.
I have that effect.
Don't twist for compliments, Mr. Davis. Core number.
So it's tab 16, page 255.
Yeah, sorry, yes.
So if I could invite you please to read from 79 through to the end of 81. That's going to cover both this ground and a large chunk of ground 4.
Okay. Sorry, to the end of which?
81, which is on page 25, completes on page 257.
Thank you, yeah.
then they go on at 82 to make the same point, which is in their mind, there is a disconnect between the utility that the training materials have in terms of laying out in terms what the job involves from the question of fact as to whether or not someone has specifically received it. The second round of opposition is more directly relevant in the sense that what was said to the tribunal was, when you look at the sample claimant relevant training material, it tends to be aspirational. In other words, what was said was that it doesn't actually describe what is done, but as it were, set some standard of perfection to which sample claimants may or may not rise. That was dealt with in this same judgment. Scrolling back a little, at 254, you will see an extract from, not only from Mr. Bryant's skeleton argument about this suggestion that the training materials for sample claimants, in contrast, it has to be said, to the training materials on Tesco's case for comparators, were aspirational. And I certainly commend reading it because it's very clear, but the summary of it is that it wouldn't be appropriate to reach a conclusion that the content of the training materials were merely aspirational. This is what's said at paragraph 231, quoted at 255, page 255, and or should be disregarded by the tribunal for any other reason. And at 78, you'll see what the tribunal says is, having by then, as we describe in paragraph 89 below, spent over a week determining the factual disputes relating to the Mrs. Worthington, we came to the clear conclusion that those submissions of the Harker's claimants were entirely correct. So there were two challenges to reliance on the training material. You shouldn't rely on it in principle unless they'd had it, and in any event, this was merely an aspirational statement of what Tesco accepted, and both propositions were rejected in the first judgment.
Yeah, so just to make sure I've understood, you are endorsing what they substantively said, but the broader point is that it can't be said that questions about how to use the training materials, came out of the blue and hadn't been addressed.
Yes.
Yeah.
And furthermore, I was going to say at risk of repeating, but I know I'm repeating, all parties used it for other purposes. So we used it to help populate the EVJDs. All parties used it in cross-examination. All of that material was relied on by all parties as having a relevance to the question: what work did people actually
But also
do?
on the question of procedural irregularity more broadly, of course it's all very odd what happened.
Yeah.
But the tribunal said in Judgment 1, we think this has all taken a wrong turn, we think this is the right approach, and that came as a complete surprise.
Yeah.
But they didn't actually follow it through until they had had a very lengthy CMO and been over and given everyone the opportunity to say what they wanted to say about the new turn that they were proposing to take. Perhaps that's what you were about to say.
No, in fact,
But I just wanted to get it into my head how it fitted it together.
that's right. In fact, it goes a little further than that, which is that, that by the point of the CMO, the tribunal's position was in effect: you lot go out and do this again. We want new documents from you, and we want fresh job descriptions. So it's slightly confusing. What they said is, you've got it all in one document at the moment, the EVJ. We want that broken up, and we want you to redo the exercise of job description, and we want you to start with the training materials and then take it from there effectively. So do what you didn't do before, focus on the training materials first. And we said, well, this is how it actually worked in practice. I said, really sorry to have disappointed you last time, and we are very anxious to get it right this time. So can I just be absolutely clear what it is you want me to do? And I thought we had worked that out. Then we went away and did a sample exercise. We calculated how long it had taken us to do it. Went back to the tribunal and said, this is going to take us a very, very long time indeed. This is how much it's cost us to date. But we handed them the sample, The tribunal said, in effect, that's not what we wanted either. At which point there is metaphorically a deep judicial sigh, and they say, right, we're going to do it. So that's what the second judgment is. They say, we are going to set out how we think it should be done by way of appendices and in narrative form, as the EAT accepts. So rather than having our table, we're going to comprehensively state what the work is. So that's when they produce that, they come back to us and say, we know this wasn't how you intended to do it, and because we have performed the exercise ourselves, it's only fair that you be given a proper opportunity to say to us if you think we've got anything wrong and that we need to reconsider it. They gave us much, much longer than the rules would normally allow us, and about a year later they faced mammoth reconsideration applications, which we say probably they ought to have anticipated was going to happen. That then produces the first reconsideration judgment. Later there's a second reconsideration judgment, but it had been, they had planned to do one thing at the end of the first judgment. In the end they don't do it. They take the responsibility on themselves. So concluding this point, we think there's a principled objection to the notion that we were put to a disadvantage, that we hadn't, as it were, mustered the evidence necessary to challenge the reliability of the training materials, which goes beyond the fact that there was a challenge to the training materials. And that's this: what would the evidence be to challenge the training materials? The answer really can only be that you demonstrated through your evidence that they didn't accurately reflect what people were doing in practice. And since that was the evidence that was before the tribunal in any event, called by both sides, we just don't understand, and there's nowhere being explained what additional evidence would have been crucial. Each party was already turning up to provide a comprehensive account of what everyone did. Some of it was agreed, so it wasn't an issue. Other bits weren't agreed, and so they were covered by the end. But our entire aim was to make sure, and everyone's entire aim was to make sure that the tribunal had in front of them everything they needed to reach a conclusive view as to what was done.
So is that a submission that even if they didn't go about it the right way, the procedural irregularity had no practical consequences?
Exactly. So if one asks in the abstract, well, if they hadn't done it this way, what would we have done differently? The answer is, well, we just have read the same evidence, which is what we say the claimants and the comparators did. And then we'd have said, insofar as that differs from the training materials, prefer the oral evidence, which is also what we did. Not what we did, but what we had the opportunity to do if we wanted to. So that really brings me to, I think, the end of subparagraph C, and subparagraph D, I don't think Mr. Reid developed and doesn't add very much, that there were misdirections which undermine the judgment as a whole. I'm not quite sure what that means. But I commend to you the authorities that the AT has already taken into account. And I add, as a matter of personal pain, Jones and Nicholas Underhill, which is, if I remember rightly, my first trip to the Court of Appeal, where the Court of Appeal decided that the judge who'd said he was bound meant that he wasn't bound. And set out this principle. The guiding principle when it comes to construing the reasons of an industrial tribunal at appellate level must be that if the tribunal has directed itself correctly on the law and reached a conclusion which is open to it on reasons, the use in other passages of its reasons of language inappropriate to the direction it has properly given itself should not be allowed to vitiate the conclusion unless the relevant words are missing no explanation save error of law. I think it's a nice way of putting really the point that appears in the other authorities anyway. If when you look at this judgment, we say to sort of address the burden point that Mr. Reid put, if you think they get it right in some places, wrong in other places, then providing they're getting it right in some places, and you're satisfied they're entitled to reach the conclusions they do in the evidence in front of them, which in effect we say is not properly otherwise challenged, the burden is on the person trying to set aside the judgment to say there's no way of reading these other passages other than that they amount to an error of law. So Mr. Reid's fallen short of that. So I've got an eye on the clock. I've got, I think, what's likely to be another 20 minutes to 30 minutes to go, for which apologies, but I'm not in a position where I'm going to take the rest of the afternoon or anything like it. So if this were a convenient moment.
Certainly. 2 o'clock.
All right, table